Okay. Good morning and welcome to this public briefing on the Standing Committee on Social Development. My name is Jane Wayellen Armstrong and I am the MLA for Montfie Clichy Region and Chair of the Standing Committee on Social Development. I will now ask the member in the room to introduce themselves for the record, followed by those online.
Good morning. I'm Shauna Morgan, MLA for Yellowknife North. Welcome.
Good morning. I'm Cheryl Yakla. I'm a member for the DECHO.
Kira? Yeah. Kira, can you hear us? Because we cannot hear you. Yeah, okay, there. Yes.
All right, there we go. Sorry, I'm Kieran Testart. I'm the member for Range Lake here in Yellowknife. Pleased to be here today.
Okay. Okay, thank you, members. Today we will receive a briefing from a panel for the statutory review of the Legal Aid Act. Please note this meeting is being live streamed to the Assembly social media channel. I would like to remind all members and witnesses to direct all questions and comments to myself as chair and to wait to be recognized before speaking to help us have a smooth meeting. I will now pass it on to our first panelist. Please introduce yourself and proceed with your opening remarks.
Thank you, Madam Chair. My name is John Hale, and I'm a criminal defense lawyer. And I want to begin by expressing my gratitude for the opportunity to speak to this committee with respect to possible improvements to the Legal Aid Act and its regulations. I've watched the submissions that were made to this committee back on February 6th when then Minister Simpson and Executive Director Tracy Bach both stated that the Legal Aid Act is functioning as intended. They also both told the committee that there is always room for improvement. So keeping in mind the stated purpose of the Legal Aid Act, which is set out in Section 2 of the Act as being to promote access to justice, I'd like to recommend some possible improvements. My comments are the submissions of a criminal defense lawyer who is on the legal aid panel. So my recommendations are restricted to the delivery of criminal law services, which make up the bulk of services that are provided by legal aid. Specifically, I'd like to focus on the following areas of potential improvement. First, I would recommend amending Section 6 of the Act, which at present requires that the Executive Director of Legal Aid must be a lawyer. In my view, this restriction is unnecessary and bars a number of highly qualified candidates from filling that position when that position may become open again. Second, and I'll return to these a little later in my comments. Second, I recommend that Section 9 of the Act be amended so that individuals who have an active legal aid approval in place or who have been approved in the past 12 months be deemed to be eligible for legal aid services without having to start a brand new legal aid application upon advising legal aid that their financial situation hasn't materially changed since they were approved. Third, I recommend that Section 15 sub 2 of the Act, which deals with how the Executive Director of Legal Aid assigns lawyers to cases, be amended by adding as a consideration whether there is a pre-existing lawyer-client relationship. Fourth, I would like to focus on Section 22 of the Act, which authorizes the Commissioner on recommendation of the Minister to make regulations under the Act. Specifically, I'd like to focus on 4 areas when it comes to the regulations. First, the hourly and daily rates of pay to panel lawyers have not changed since December 2014. In addition to a 29% increase to bring rates back in line with 2014 levels, there should be a built-in cost of living increase each year. Second, lawyers should be paid within 2 weeks of rendering an account, not the current 30 days. Third, the categorization of offenses in the regulations, categorized type A through E, should be revisited. I recommend that type A and B offenses be collapsed into one category, resulting in 4 categories. Also, given their complexity, sexual offenses should always be considered as type C indictable offenses, regardless of whether the Crown proceeds by indictment or by summary conviction. And fourth, finally, I recommend doubling the hours allocated for pretrial preparation, and also permitting an additional 4 hours preparation per day once the trial is underway. So before elaborating on those recommendations, I'll just tell the committee a little about myself to put my comments in context. I was called to the Bar of Ontario in 1989, and I've been practicing for 36 years now, doing exclusively criminal defense law. I was certified as a specialist by the Law Society of Ontario in criminal law in 2005. I've argued at all levels of court. I've done over 2,000 trials. I've argued in the Court of Appeal over 100 times in Ontario, also here in the Northwest Territories. I've appeared twice in the Supreme Court of Canada. In addition to practicing law, I've been teaching at Carleton University and at Ottawa University since 1990. And one of my students at Carleton ended up becoming a lawyer who did work here in the North. And being friends on Facebook, I saw his photographs and wanted to find out more. And that led very quickly in 2018 to me getting called to the bar here on October 15th. I still remember it vividly. And going directly from being called to the bar by Justice Mahar at the courthouse to hopping on a plane to Inuvik and doing a circuit later that day, and then staying on to do a jury trial in Inuvik the following week. So I've started my work here in the Northwest Territories almost 7 years ago in 2018. And in 2023, having found it more and more difficult to go back south, I couldn't resist the pull of the north anymore, and my wife and I decided to move up here, and we moved up last summer. One other fact about myself is that from 2019 to 23, I was the vice president of the Criminal Lawyers Association, which represents about 2,000 criminal lawyers in Ontario, and in that capacity I was chair of the Legal Aid Committee and was engaged for the 4 years or so with the government and with Legal Aid Ontario in negotiations that led to a fairly significant overhaul of the legal aid tariff in Ontario. So I have that background. While I don't pretend to be some appointed representative of the criminal lawyers who do work in the Northwest Territories, I do feel confident that my remarks and recommendations reflect what I've heard from other criminal lawyers who practice here, whether they're resident lawyers or whether they're out-of-territory lawyers. Working in the North has been a real eye-opener, and I don't know what my expectations were, but my eyes were opened working up here. I've been to almost every community. I've climbed the 3 hills in Ulukaktuk at midnight. I've been to Paulatuk. I've been throughout the Beaufort Delta. I've been throughout the Satu. I've been south of the lake. to multiple communities. And I've also done a lot of work in Yellowknife, particularly once I moved here. What I've seen is that the Legal Aid Commission faces enormous challenges in providing access to justice across such a diverse territory where we have a metropolitan center of Yellowknife, but the same commission has to provide services to populations in remote communities, often only fly-in communities, and actually more accessible in the winter than in the summer when the ice roads are in. The Legal Aid Commission is facing bigger problems now because of attrition, because of loss of lawyers. They've lost staff lawyers. There are 9 positions. They're down to 5, one of whom was just called to the bar this year, or I guess late last year. And the commission has to rely more on private lawyers. At this point, there are only 7 resident criminal defense lawyers, soon to be 6 because one is leaving the practice of criminal law. Non-resident panel lawyers fluctuate. Some on the panel, which I think is close to, I think there's 22 or 23 panel lawyers outside the territory, but some only come once or twice a year, if that. From my observations, the attrition is due to 2 things. One, the low rate of pay, combined with the inadequate number of hours that are allocated under the regulations, and combined with that, the sometimes traumatizing nature of the work that we do, especially in the communities, and that's led to burnout in many cases. We deal with violence in the extreme. We deal in a second-hand way with the trauma of our clients, in getting to know our clients and understand why they find themselves in the position they're in. We hear about the trauma that our clients have experienced, in particular the Indigenous clients, in particular in the communities, and it weighs on lawyers. And I've seen it lead to burnout in a number of cases. Legal aid is about access to justice. It says right there in Section 2 of the Legal Aid Act. It's not there to benefit lawyers, it's there to benefit people who need legal help. The legal aid system ensures that even the most marginalized member are competently and professionally and respectfully represented in court. When lawyers aren't willing to take on legal aid cases, it reduces access to justice. And I'm worried that we're getting to that point where legal aid is having trouble finding lawyers to take on cases. As you heard on February 6th, the vast majority of clients who are assisted on legal aid are Indigenous. In the context of criminal law, ensuring proper representation will result hopefully in lower incarceration rates for Indigenous persons, rates that are still alarmingly high 26 years after the Supreme Court of Canada decided the case of Gladue and raised the alarm then about overrepresentation of Indigenous persons. In fact, the statistics are worse now than they were in 1999. But also 10 years after the Truth and Reconciliation Commission put out its 94 calls to action, including calls to action 30 and 38 that call for the federal and territorial governments to eliminate overrepresentation of Indigenous persons in our jails within the next 10 years. That was 10 years ago. We haven't budged a centimeter on that. So with that context, I want to return to the recommendations that I set out at the outset. First, with respect to Section 6 of the Act, it requires that the executive director must be a lawyer. It's unclear to me why being executive director requires a law degree. We're lucky that our first 2 executive directors, Karen Wilford and now Tracy Bach, are lawyers who happen to have excellent managerial skills. That said, the executive director position it's a managerial position and requires different skills than those taught in law school. When the time comes that the current executive director's term ends, his successor should be someone who has an intimate knowledge of the workings of legal aid and of the justice system in the Northwest Territories. I can think of past and present employees of legal aid who would be superb executive directors, but who do not have law degrees and are therefore ineligible to fill the position. Having a law degree should be just one factor to consider. It should not be a prerequisite. It should not set a bar to entry to that position. Second, turning to Section 9 of the Act, it should be amended so that individuals who have an active legal aid approval in place or who have been approved in the last 12 months should be deemed eligible if they confirm that their financial situation hasn't changed. This will eliminate unnecessary delays in court, unnecessary court appearances, unnecessary administrative work, particularly on circuits where an individual who we all know is inevitably going to be approved for legal aid has to adjourn so that they can start a new legal aid application and provide the very same information they gave maybe 2 months ago. I've seen in recent circuits in Fort Providence and Fort Simpson where the court sits every 2 months. We can't set a trial date for somebody who wants to set a trial date because they have to apply for legal aid first. But they can't do the application while we're there on circuit. There's a court worker, and thank goodness for our court workers, they do extraordinary work, but the court worker has to gather the information and send it here to Yellowknife. A decision is made here, but it can't be done within the week of the circuit. So then we either have to adjourn to the next circuit 2 months down the road to set a date for trial, or we have to set some interim date in Yellowknife where the client has to find some way to appear in court remotely from whatever community it is in order to set the date. It puts an extra burden on court workers who have to gather information. It presents a hardship for accused individuals who have to rustle up their bank statements again and find all the information, which often isn't easy in the communities where there's not ready access to internet or photocopiers or whatever is needed. I can tell you from my experience in Ontario that it is entirely routine that if I'm representing a client on one set of charges and now they get a new set of charges, I just go online and in literally 1 to 2 minutes, I click off a few boxes and a new certificate is issued for that client, as long as I confirm that the client's financial situation hasn't changed. My third recommendation relates to Section 15, Sub 2 of the Act, which deals with how the executive director assigns lawyers to cases. I'm suggesting that it should be amended to add as a consideration that there is a pre-existing lawyer-client relationship. In the Northwest Territories, other than in murder cases, clients have no say in who their lawyer is. There's no right to counsel of choice, which arguably infringes the Charter of Rights. In communities outside Yellowknife, this is necessary, as legal aid can only send 1 or 2 lawyers on each circuit. So legal aid can't send a team of lawyers, 1 for each client, but instead lawyers have to be assigned. But in Yellowknife, there's no reason that I can see that justifies disrespecting an individual's choice as to who will represent them, particularly if the individual already has an established relationship of trust with one lawyer. In fact, taking away this choice disenfranchises individuals, most of whom, as we know, are indigenous and are already feeling marginalized in the criminal justice system. And it causes these individuals to feel like they have no agency in one of the most significant events of their life. In fact, if somebody asks for a particular lawyer, it makes it even less likely that they will get that lawyer. If I've represented somebody and have established a relationship with that person, and that first person has confided in me, has trust in me, it to me makes no sense that they should have to start over from scratch and establish a whole new relationship with another lawyer. It should be taken into account as one factor to be considered, that there's a pre-existing relationship, so that clients aren't kind of shunted around like pawns on a chessboard, just assigned to whoever's next up on the list. Fourth, I'd like to turn to Section 22, which deals with the regulations. Specifically, the four points that I brought up earlier. So first, the hourly and daily rates of pay to panel lawyers have not changed since December 2014, even though pay rates for all other justice participants, police, judges, Crown attorneys, probation officers, all government employees have seen their rates go up with inflation. Taking inflation into account, panel lawyers are now paid 29% less than what they would be paid had there been annual increases to account for cost of living since 2014. Looking at the various reports put out by the Legal Aid Commission, I see that in 2006, rates were raised for the first time since 2001, and then they were raised again in 2014 when the Legal Aid Act came into effect, and they haven't been raised since. And in 2006, there's an interesting passage from the Legal Aid Commission's report that year, the 2005-6 report, says, after hearing submissions from representatives of the private bar, the board at its December meeting recommended to the Minister of Justice that the tariff be increased by 15% for both hourly and daily rates. The tariff has not been increased since 2001, so 5 years earlier, and has not kept pace with increases in the cost of living or with increases given to government employees over that time period. The board also felt that an increase might assist in attracting lawyers to legal aid work. So that was in 2006. The very same comments can be made now, but it's even more critical because it's been 11 years without an increase. Second, in terms of the way lawyers' accounts are paid, panel lawyers, obviously not staff lawyers, accounts are supposed to be paid within 30 days or at 30 days after they've been submitted to finance for payment. In Ontario, it's 2 weeks. I don't see any reason why we have to wait 30 days to be paid, and it has to be kept in mind that often we're carrying significant disbursements. When I'm going to Inuvik next week. I had to book that flight a month and a half ago. I can't bill for that until after I finish the circuit, and then I got to wait still another 30 days. In the meantime, I will have accumulated hotel expenses in Inuvik, and all of us lawyers who do work outside Yellowknife are carrying these expenses until they get paid. There might also be a mechanism whereby disbursements can just be paid immediately rather than wait until an account is submitted. Third, the regulations, in particular the definition in Section 1 of Type A through E offenses need to be updated to reflect the current realities of criminal trials, including increased complexity. In 2019, the criminal code was amended so that summary conviction offenses or hybrid offenses where the Crown could elect by summary conviction had their maximum penalties increased from 6 months to 2 years less a day. And as a result, the Crown is now electing by summary conviction in situations where they used, or by summary conviction, where they used to elect by indictment. The complexity of the work has increased at the same time that the penalties have increased. Disclosure in criminal cases is voluminous. I used to get a paper file with 30 to 50 pages. Now I get gigabytes or even terabytes of data in some cases. I get my disclosure on a hard drive. So the distinction between the Type A and Type B offenses is really non-existent anymore, and they should be rolled into one. Also, sexual offenses in particular have taken on enormous complexity, again, as a result of changes to the law that require pretrial applications for admitting records such as messages, WhatsApp messages, Facebook messages, etc. Sexual assault trials take on a life of their own and have typically doubled in length and doubled in complexity, tripled in complexity. And in Ontario, they're always treated as indictable offenses for legal aid purposes. They should be here as well. Just because the Crown elects to go by summary conviction should not turn it into a situation where the lawyer can only ask for 7 hours of preparation time before asking for discretion. But that's the maximum now. Finally, the maximum hours of preparation provided for are woefully inadequate. They range from 7 hours for summary conviction offenses up to 50 hours for the most serious offenses, including murder. No lawyer can properly prepare for a murder trial in less than 100 hours, or for most common trials, whether they're sexual assaults, break and enters, in less than 20 hours. But the maximum for these are 7 to 10 hours. It's rare that we get a charge like an aggravated assault, robbery, where the 20-hour maximum is allowed, but in those cases still 20 hours is inadequate. It may be that this committee is not the proper forum for making recommendations as to changes to the actual tariff in Ontario. It's been incorporated into the Legal Aid Act there that there's a built-in mechanism for tariff review, and it's not every 10 years. But one way or another, I think the tariff needs to be seriously looked at, both in terms of the categorization of offenses and in terms of the number of hours that are allocated per offense. Of course, lawyers can ask for more. We are at the mercy of the executive director, whether the executive director will pay for more. We don't want to be going hat in hand to ask to be paid for the work that we did. The number of hours set out should appropriately reflect how much work is typically required for not only representing people at trial, but also in other areas, such as bail hearings, bail reviews. Bail review here, just as an example, we get paid 5 hours. Ontario, it's 10 hours. and that accurately reflects, a lot of work went into coming up with the hours in Ontario. It reflects how much time is needed. And I think pretty much across the board, the hours allocated for pretty much everything are about half of what are needed. The way it is, our executive director is inundated with requests for discretion because it's almost impossible to do the work in the allocated hours. So our executive director has to be spending a lot of time fielding requests, time which I expect could be put to better use. So those are my comments and recommendations. I, again, very much appreciate the invitation to speak here and the opportunity to provide my comments, and I'm happy to take any questions. Thank you, Madam Chair.
Thank you. Thank you for the presentation. Now, I will now ask the member if they have any questions. Shauna?
Thank you, Madam Chair, and I really very much appreciate the presentation. There's a lot of insights we gained here. Okay, one question I have. You were talking about how currently the executive director seems to have total discretionary authority around how they assign lawyers to cases. That's my understanding from what you've said. And you also said that if someone is asking for a particular lawyer, such as someone they've worked with before, it makes it even less likely that they would get that particular lawyer. Can you explain what is the thinking behind that? Is there a general philosophy or sort of way of thinking from the director that people shouldn't get the lawyer of their preference, or there shouldn't be consistency in legal representation? Or can you explain like why the system currently works that way according to your understanding? Thank you.
Just wait. Okay. Thank you. Thank you, MLA Morgan. Mr. Hill?
Yes, thank you, Madam Chair. My understanding, and there may have been some shift in the thinking, but certainly when I started back in 2018 and over time since then, is that the idea was that no lawyer should be favored, and that work should be spread evenly amongst lawyers who want to do the work up here. And the concern was that if lawyer A or lawyer B somehow became popular, got a good reputation, everybody would want that lawyer, and there'd be more work for that lawyer and less, as a result, for other lawyers. So lawyers were kind of randomly assigned. It was like the taxi queue. It's the next up would get the client. There have been some changes, and to be fair, I've had situations recently where I have represented an individual, and legal aid has reached out and said, this person's in trouble again. Would you be willing to take this file on again? I've experienced that more where the person who kind of by default would have taken that client didn't want that client for some reason, so then they would turn to me. But I think the philosophy was to make sure that the work was evenly spread out amongst lawyers.
Thank you. Ms. MLA Morgan, do you have a follow-up question? Okay.
Thanks for that. I mean, that helps us understand better, but it also seems backwards that lawyers or clients should be sort of punished for, doing a good job or having that person feel that they really were well represented and they want to continue that relationship. It seems counterintuitive that we're like, no, now you're too popular, we have to take you away. Anyway. Another question of clarification I have, so under some of your recommendations around the regulations, and you talk about Number 3 is, I think, harder for us lay people to understand. Regulation 1 should be amended so that type A and B offenses are collapsed into one, and categorizing sexual offenses as type C. Is the significance of your recommendation have to do with the number of hours that get allocated for each type A, B, and C offenses? Or can you just sort of give us a shorthand on why that recommendation is significant? Thank you.
Yeah.
Yes, yes, go ahead, please.
Yes, thank you, Madam Chair. So, under the regulations, I just want to get to the right page here, but there's a table that sets out the prep time, that the maximum time that's available for any offense. So, it's Table 2. For Type A offenses, there's a maximum of 7 hours. And these are summary conviction offenses. So these are the least serious offenses. Under our criminal code, there's 2 types of offenses. There's summary conviction and indictable. Indictable are more serious, summary conviction are less. There's a whole swath of offenses that we call hybrid or Crown election offenses, where the Crown can choose to go one way or the other. They can elect by summary conviction or by indictment. So Type A offenses are either straight summary conviction offenses, which there aren't that many of, or they're hybrid offenses where the Crown has elected by summary conviction, maximum 7 hours. Type B offenses are indictable offenses that carry no more than 5 years jail. They qualify for 10 hours of preparation time. Type C, similarly, qualifies for just 10 hours. They're indictable, but they carry more than 5 years, but not up to life in jail. So up to a maximum 14 years. Type D offenses are, they carry 20 hours. They have a maximum of life, but they don't include the murder charges. So murder is Type E offenses, and they carry 50 hours of preparation. So given that summary conviction offenses now carry a much longer penalty than they carried back in 2014 when the law was passed, and given that the complexity of those files is basically the same as the Type B offenses, it's a totally arbitrary distinction now. There's no need to have Type A and Type B. They should really be collapsed into one.
Okay.
Thank you,
Okay,
Madam Chair.
Thank you. Now I have Ms. Yakalaya, MLA Yakalaya.
Thank you, Madam Chair. My question is, and thank you to Mr. Hale for your presentation and your recommendations, and that's certainly something for us to consider. My question is, are there any areas of legal aid that you feel would be worth adding or expanding on that would provide further support to residents? For example, estates. Thank you, Madam Chair.
Yes, thank you. Mr. Hale? Yeah.
That's, frankly, it's difficult for me to answer because I'm really only familiar with the criminal law area. I did see that question come up in the February 6th presentation as well. I gather that this type of a thing is addressed in the context of the clinics and the outreach clinics. But I think legal aid traditionally doesn't get involved in like money matters or land matters, not just here in the Northwest Territories, but anywhere. Sometimes they get involved in civil actions, but legal aid tends to be focused on criminal and family law.
Yes. Thank you. Ms. Yakalaya, do you have a follow-up question?
Yeah. Oh, sorry, it automatically goes on. Thank you for that. And Madam Chair, thank you, Madam Chair. What about people that are dealing with rental arrears? Like, it's not only for estates, it could be different things that, you know, is it worth adding or expanding on these to provide further supports to residents? That's the question I had. Thank you, Madam Chair.
Okay. Thank you, Mr. Hill.
Again, I think that the clinics provide that type of advice. I gather that they've reduced the hours, though it used to be, I think, 3 hours per client was provided, and it's been reduced to 1 hour. But I think that type of summary advice is provided. If the legal aid budget was increased, I could certainly I could certainly see a need for that type of service to be provided, because I appreciate that a lot of people who are paying rent are just barely able to pay their rent, and they're probably being faced with rent increases or other issues. And I could see the need for legal assistance in those cases beyond what a clinic can provide in an hour. But we'd have to expand the envelope of funding to legal aid.
Okay. Thank you, Mr. Ekalai. I have Mr. Testart on the line too as well to ask questions. Go ahead, MLA Testart.
Thank you, Madam Chair, and thank you, Mr. Hale, for presenting to the committee today. I asked the executive director around the functioning, like the day-to-day operations of legal aid, to see, because that's really where the rubber meets the road. It's good to have your evidence here to understand your experience as a panel lawyer. You mentioned the tariff in Ontario has been moved into statute rather than in regulations. Do you know what the rationale for that was? Thank you, Madam Chair.
Okay. Mr. Hill?
The tariff in Ontario is set out in regulations to the Legal Aid Act there as well. The Legal Aid Act, it's similar to here, where the broad principles and guidelines are set out in the Act, but the actual figures are set out in regulations. Ontario did leapfrog over Northwest Territories last year in terms of hourly rates, and Ontario's actual hours allocated per files is way more than what we have here in the Northwest Territories, double in some cases. And Ontario also permits billing of preparation during trial. Here in Northwest Territories, we just bill our daily rate. So even if we're in court all day and then working till midnight, we effectively get 6 hours.
Okay. Thank you. Mr. Testart, do you have another question?
No, that's fine. I think that's sorry, I misheard something, but I think that those are areas we can look at. Yeah, like the Ontario. Would you say the Ontario? I mean, is it more because Ontario is very current legislation and they've made these changes that you're drawing inference or bringing it to our attention, or is it more so your familiarity with that system as you've practiced there? Thank you.
Okay. Thank you. Mr. Hill?
I'm bringing up Ontario more because of my familiarity with it, having been involved in the negotiations. I know that in Alberta, in the last couple of years, there was a significant change to the legal aid system there as well. But my understanding is, again, it's similar in structure in that there's an act and then there's regulations. And the reason for regulations is they can be updated as need be in terms of dollar figures and hours. It's not as easy to amend the statute.
Okay. Okay, thank you. I do have a question too as well. I know that looking at the legal aid acts in front of us, we know that we are way behind some other jurisdictions. We know that we're behind Nunavut, And it's good that, you're highlighting Ontario's one, and I know that we have a lot of work ahead of us, so which is good, and I do appreciate your presentations. And, within your, since you've been here 1 year, it's almost a year now, eh? And I know in small communities, we have issues, The only time that we see lawyers is when the court is happening, and usually they're busy. And there's a lot of other community members, they have questions, not related to, criminal law, but they have questions how to deal with housing eviction. They have, because some of them, they don't really understand the terminology, so it gets messed. And if they don't contact you right away, it's too late to deal with some of the most important issues, like with housing evictions, and how to appeal, I'm dealing with one right now, and I hope, we are, working on it, and it's a practice for all of us, even especially with the tenant. But in your view, being here, since last year, do you see more attention or focus or services given to criminal law than civil law? Thank you.
Yes, there's certainly, I would say there's way more attention given to criminal law. I think criminal law is overwhelmingly the focus of legal aid and the Legal Aid Commission. I appreciate that question because it brings up, something that's kind of on my wish list. And again, it would require more funding, but I've been going to communities for almost 7 years now. And it's always struck me that we, the court party, we land in the community, we get into RCMP trucks, and we get there as one unit, the traveling justice show. We get there, and I feel like we're bringing our justice system and imposing it on people there without really getting a chance to meet people. And I wish we could get there a day early and like just be in the community for a day and meet people rather than, recently I was in Fort Simpson. We flew out of here in the morning, got to the airport, went straight to court, and met clients I met clients in the change room at the arena in Fort Simpson. It would be so nice to be able to go there a day early and have that count as a circuit day as well, and be in the community. I know the Crowns do it. The Crowns go up there early. They have funding for that. But just so that the clients see us defense lawyers as not part of the traveling justice show, but we're there for them, because it leaves a bad taste in my mouth that we're all seen as part of the same group of people coming from Yellowknife or coming from the South to bring our justice system. And to add to that, maybe when we go to the community with 1 or 2 defense lawyers, maybe legal aid, or maybe somehow we could provide 1 other lawyer to go to meet people that week to discuss the landlord-tenant issues and provide other advice, so that there's, at least every couple of months, there's a lawyer who actually comes to the community. Failing that, set up some system where individuals who want legal advice could meet by Zoom. It's difficult for people in the communities to do that, but if there was some facility where they could meet lawyers by Zoom, I think that would give more access to justice. And again, that's what the Legal Aid Act is about. And access to justice isn't restricted to criminal law.
Okay. Thank you for the information, because I know it is really frustrating for a lot of our members, our community. You know, they get to see a lawyer or legal aid. You know, mostly it's going to be legal aid because that's the only one that's available. And those with money will have their own private lawyer, and, you know, it's not too often. Because of that, we know that our people are not getting a fair representations. And right away, you know, like, I mean, they're, you know, found guilty, and, you know, why do you think we have over representations in our correctional system? So, but all this information, it's really, it's good for us to know. And I know that we have a lot of work ahead of us. So it's more of a comment, but then if you want to, you know, it's up to you, but it is frustrating. It is frustrating for many of our communities that really want to get a fair representations, and they're denied that, you know, and it is sad, you know. It's sad because we see them in jail, and it's some of them shouldn't even be there. Some of them, yes, maybe it's beyond our control, but some of them it's for, you know, I mean, if they were. Yeah, so it's just that it's lacking a fair representations, and I do hear you, and I glad you gave us the recommendations. It's something that we can, you know, well think about, and it's something that we can work with. So, but it's more of a comment. But if you have any other comments you want to make, then, you know, please proceed before we end. Oh, okay. I do apologize. Forgot to ask for a second set of questions. I do have two members. Yes, Ms. Morgan.
Thank you, Madam Chair. I have one more question. You had mentioned that there's been a loss of a lot of lawyers, like there's vacant positions at Legal Aid from 9 positions, but there's down to 5 on staff. And I know that, I guess as of 2014, it switched to kind of a hybrid model where they would contract, you know, private lawyers to supplement. Is that system working well, that even though they might be losing staff, like direct staff working for legal aid, are they just sort of making up for that by tapping into more private lawyers? Or is that a concern to you, that system, or does it work well just to make up for loss of staff lawyers by using more private lawyers? Thank you.
Thank you. I have to switch real quick. Thank you, Ms. Morgan. Mr. Hale?
Thank you. I think the system works well, having this mix of staff lawyers and private panel lawyers, whether they're from within or outside the territory. Certainly in criminal law, and I expect in family law too, you need as many lawyers as possible because of the conflicts that arise. I'm finding that I'm unable to represent a lot of people now because I'm conflicted. You know, the person I represented last year now is the victim in the case, and I'm being asked to represent the accused in that case, but I can't. So we're constantly, especially in the smaller communities, dealing with conflicts, and lawyers get conflicted out quite quickly. So we need a fairly large roster of lawyers to be able to take on cases. I mean, there's some cases where the only witnesses are police officers, but where they're civilians, again, especially in the communities, when I sit in court, the courtroom is filled with people who are there both as witnesses and also as accused. Yeah, we need multiple lawyers for conflict reasons.
Thank you, Mr. Hill. Ms. Morgan, do you have another follow-up question? Okay, thank you.
We'll just leave it there.
Okay. Is there anything, Mr. Tester? Mr. Tester, do you have any questions? Any further questions?
No, thank you, Madam Chair. I think Mr. Hale has well explained his points, his recommendations, and I have no further questions.
I have a question. Question I have is there a reason why the Gladue report is not being used in the Northwest Territories? Can you answer that question? Thank you. Mr. Hale?
I come from a jurisdiction where Gladue reports were quite common in Ontario, and they were very helpful. And we also had the IRCA reports, the race and cultural for Black clients. Here, I think, given that the vast majority of individuals are Indigenous, you'd need a Gladue report in every one. I don't think there's the person power to produce that. I have seen pre-sentence reports, though, that do address the issues set out in Gladue. Pre-sentence reports, invariably, if they relate to an Indigenous client, will have a couple of pages that set out, that provide some context, Indigenous context to the accused behavior. It's not as compendious as the Gladue reports I've seen. I mean, the other thing I would point out is that the Gladue reports I've seen in the South are written by Gladue writers who are not government employees. They're independent, whereas here they're written by probation officers who are part of the justice system. And I don't know that clients feel quite as open, and because I find invariably there's some distrust of people in the justice system. So having an independent writer would be helpful. I just don't know where we would find the people to do that. In an ideal world, yes, there'd be a Gladue report in every single case.
Okay, thank you. Ms. Yakalaya, do you have a follow-up question?
Yeah, I do. Just for context for our for people that are watching, can you elaborate on a little bit about what the Gladue report entails? Thank you.
Mr. Hill?
Yes, so in 1999, the Supreme Court of Canada decided the Gladue case, and it's a landmark decision where the Supreme Court validated statistics and research that was put before the court about the overrepresentation of Indigenous persons in our correction system, both in terms of being charged and in terms of being in jail and in terms of being on probation, but caught up in the system. And the Supreme Court back then was really clear that there is an overrepresentation to the shame of Canada, and something had to be done about this overrepresentation. And as a result, it was incumbent on justice participants, in particular judges, to take into account a person's Indigenous ancestry, to factor that in when determining what the appropriate penalty would be. It's not, some people have the idea that the Gladue decision stands for the notion that if you're Indigenous, you shouldn't go to jail. That's not what it says. But it does say that we have to take into account a person's ancestry and do whatever we can to reduce overrepresentation of Indigenous persons in our jails. The sad reality is that the statistics haven't changed. In fact, in COVID, they got worse. In COVID, we emptied out our jails to stop the spread of COVID, but non-Indigenous persons were released more than Indigenous, so the overrepresentation actually went back up. Gladue reports are reports authored by, normally by Indigenous persons themselves, who have a deeper understanding of what they're writing about, who will talk about the accused and their family and going back, because we know that there's generational trauma, that, you know, it's almost genetic, you know, that the trauma suffered by somebody 2 or 3 generations back still filters its way down to the current generation. And that may have been counterintuitive to some people, but the Gladue decision makes it clear that this is a factor. This is why some people get involved in the justice system. So Gladue reports are intended to fill in a lot of blanks, a lot of missing information, so that judges can impose appropriate sentences. Rehabilitation is always an objective of sentencing, and you know, there should be sometimes a more restorative approach to sentencing. You know, there's kind of, if the only tool you have is a hammer, then everything looks like a nail. That's kind of what we see. You know, jail is the go-to answer for so many offenses. So, you know, so many clients ask me for a Gladue report, and I'm frustrated to tell them there's really no such thing here. I suppose somebody, if they had the money, could privately commission one for themselves, get somebody from the South to write one. Anyways, that's what a Gladue report is. It's to fill in information that would not typically be covered by a pre-sentence report, which a pre-sentence report covers things like the accused mental health background, their employment and education background, their family history and their circumstances, but it doesn't get into their Indigenous background. They do here, though, for a page or two.
Do you have a follow-up? Okay, thank you. Thank you for the information, and I think if there's no more other questions, then I would like to say thank you to our presenter for the presentation, for joining us today. So this concludes our public briefing from a panel for the statutory review of the legal aid. So I would like to say thank you. Thank you for coming, for joining us today.
And thank you, Madam Chair.
Mm-hmm.